situation, we might actually get to this point where we have this industrial copyright, which André talked about, which is our idea. We're not just against something, we're against software patents because we have a better alternative, which is our idea of industrial copyright. But nevertheless, we still have to put up with the things that are happening now, which we did in the software patent debate. And maybe you're asking yourself, what happened in this year? Because we always kept you up to date until this point. And you heard that we had another decision on software patents last year, which was preceded by a very theatrical installation where we had lots of, it was funny, we had lots of companies that came up and said we want software patents, and then you found out that these companies just started to exist and probably just for the purpose to be a company for software patents. And we also had lots of we had lots of interesting things happening, like when the European Council debated on software patents, they put the item of software patents on the schedule of the Ministry of Agriculture and Fisheries. No, not Ministry, but the Council. And of course, software patents are very much related to agriculture. Well, and the good thing was we had Poland, and Poland deleted this item from the list. So they brought it up again, and it was again added to the list, and Poland deleted it again. So they had to put up with the problem behind it, which was the debate. Also, we had interesting offer for members of the parliament to get ice cream if they vote in favor of software patents. Well, it's not exactly corruption, but it comes very close, I think. But in the end, all these measures that as it was called, the Goliath Party, but I don't think that's adequate. It's just we could as well call it the Tortoise Party because they were so incapable of adapting to the situation. They were not very successful. In the end, we had the parliament decision against software patents, and this means that this part of our fight is over, but still we have this threat, and we're very much sure that things like software patents or intellectual property enforcement directive, which I'll come to in a second, are going to turn up again and again. And so what we need now is a directive that says that software is not patentable. As I said before, we need to clarify that we're not obliged to have software patents by the TRIPS agreement, and we need to clarify that we don't want software patents in Europe. We did this before, but not on the EU level. It's just this European Patent Convention, which some people have a very funny opinion about. Okay, now I mentioned the IP Rights Enforcement Directive, which is another part of the software patent problem, especially in combination with TRIPS, because what we had was a directive that stated that all intentional infringements on intellectual property rights, which wasn't not specified, it could be any intellectual property right, that any of these infringements had to be, had to involve criminal sanctions against the person committing the infringement, which is, imagine you write software, as we always do every day, and you get in jail because someone thinks that you violated the patent. But yeah, even if you don't get in jail, you're still, if it's a criminal sanction, you're a criminal in this case, because you violated the patent in an intentional case, because intentional is not really defined, nor is the term of intellectual property right, which one was affected and which ones are not. It could also be your last name is the name of a big famous company, so you're violating trademark rights, and are you a criminal then? What we have here is the directive I'm talking about, and we could look into it.
It's a double directive, a very special style. It's a framework decision and a directive, but the European Court of Justice ruled that other procedures have to be used. So this directive now is stalled and will pop up next year again, probably in a very similar fashion. And well, the structure is that the Commission explains why certain parts of the directive are needed. Then we have recitals, and what I encourage everybody is to actually read those directive proposals and always go to the source, so to speak, the primary source, which is the legal text, and don't stick to press releases or whatever, because often these press releases or what politicians talk about, those measures, this changes. But what's actually written in there is what counts in the end. And here we have Article 3, which is very broad. And they say it's derived from TRIPS, but TRIPS has a different and I think better wording. This is rejected, Article 3, in the current form, not only by us, not only we think this is dangerous, but the whole other industry, I think also the BSA and so on, because this is so broad. As a member state shall ensure that all intentional infringements, in German vorsätzliche, I think TRIPS says willful infringements and is reduced to copyright and trademark violations, and here all intentional infringements of an intellectual property right, which is not really legal language because the term intellectual property right is not defined. Perhaps at the WIPO, the World Intellectual Property Organization, they also discuss traditional knowledge. Now expect a violation of traditional knowledge, intentional violation of intentional knowledge would create criminal sanctions or like that. So they use terminology which is not really defined yet, which is derived from a lobbying context, not from legal language. On a commercial scale, well, this is of minor importance usually, and attempting, aiding, or abetting and inciting such infringements. This even broadens it, are treated as criminal offenses. So what has this to do with software patents? It's very easy to infringe a software patent. It happens to big companies. Often you don't really know whether you infringe a patent or not. All intentional infringements. The question is, of course, the hard criteria here is intentional. But the question is, how will this be interpreted in the courts? What's an intentional infringement, say, of a patent or of a trademark? So this could be very dangerous. We currently have such regulation in place in Germany, I think in the Netherlands, about when you infringe a patent intentionally, that you can be prosecuted by criminal law, I think, or in Germany or the Netherlands. The reason behind it is, of course, because of this TRIPS agreement, which says that such measures shall be provided. But these measures are, first of all, hardly in use. This is one part of the problem. And the other part of the problem, when they are in use, and you will find that when you Google the internet, when you should use this, is they're used in civil cases, of enforcement cases, in order to get proof. Because criminal offenses are treated by the state. So the state attorney cares about it. And you don't have to spend that much money. And there's another problem in this directive, despite the wonderful thing that the penalties are harmonized, which is in the framework decision currently. This is joint investigation teams, which the German BMJ is very critical of. Which means that rights holders shall assist the law enforcement authorities here, Article 4, joint investigation teams. And so this is also, they are also critical about that. This IPR2, how we call it, is introduced, and all these criminal sanctions were left out at the IPR Enforcement Directive 1. And they were left out, and this was presented as a kind of compromise because everybody rejected to include them. Now, we think this is dangerous regulation. The case under which it is put forward is product piracy. You know, this watches or like that, Rolex watches from Southern Europe or things like that. And interestingly, the EU currently has, for the customs, has regulation in place for that purpose. And this regulation from the customs regulation about what product piracy is and so on is totally incompatible with this law. It's different and it's better. It's even better what we currently have in place in order to prosecute such real criminal acts of organized crime. So the existing framework is much better than what they propose here.
Just as a side note, another funny thing we find in this directive is that on the set of criminal provisions, you have this ban on access to public assistance or subsidies, and well, it depends on the definition. This is always a problem in this directive, that most of the wording used is not correctly defined. So if you really extend this directive to a per person level and you're writing software and you're getting HARTS 4, then you might be banned from getting HARTS 4, which is interesting. Just as a side note, it's a matter of interpretation, which is always a problem with these laws, because no one knows how to interpret them, and the interpretation changes every couple of months until court steps in and decides it, and you can't predict that. Anyway, why we're telling this to you is that we're looking for OpenOffice. There it is. I found it. Why we're telling this to you is that we think that some of you are interested in this topic, otherwise you wouldn't be here. And we think that you can help us because we're the FFI, but you're the people that make up Europe, and you're the people who want their rights defended. And also, I think you have some time. So what we're trying to do is to teach you to defend your rights, which we'll get to in the end. You don't have to go to Brussels. I don't mean that, but it's just an introspective of what is going on there. You have lots of parliamentarians and other people who make decisions, and you have all these lobbyists hanging around them, telling them what they think is right, and of course everyone thinks that something else is right. And the one thing that we're missing in Brussels are people who are telling them what you think is right, and this is our mission.
Actually, these pictures are from our event.